Welcome to Property Chat with Lucy, where real estate meets real talk. I'm your host, Lucy, and I want to take you through a journey of the basics of real estate, unfair, at times traumatizing stories in real estate. You're gonna meet industry experts here, and also I'm gonna share with you market trends on real estate, so you don't wanna miss out on this. So look forward to an amazing time with me as I get you into my world of real estate. Every episode, I intend to educate you, inform, and inspire you. So stay tuned to this. Hi, my lovely people. Welcome back to another episode of Property Chat with Lucy, where real estate meets a real talk. And guess who I have on set again? Mimi. I'll let Mimi introduce herself before I introduce to you what we're about to dive into in this episode.
Hi, thanks, Lucy. My name is Mimi Aldrin Amulioto. I am the managing partner of Amulioto and Company Advocates. I'm an advocate, commissioner for oaths and notaries public. People now add LLB, Diplo, and all that. I have been in the family law space for quite some time, being a family law practitioner. Family law being anything to do with children, divorces, matrimonial property, as well as succession, which is now the dealings of property of someone who's passed on. So that's in a nutshell, apart from me being here again.
All right. Maybe just to introduce myself, sorry, because I know probably there are new people in here.
Yeah.
My name is Lucy. I'm a realtor, and I call myself a property consultant. So what you're talking about today is something that I've experienced firsthand, and I thought, why not have like a very real conversation around this topic? And you don't want to miss about it, all right? Now, just imagine a family member has passed on and they've left huge, massive investments. And this comes with trauma, emotional trauma. It comes with sibling rivalry, legal complexities. I wanted us to explore the ways to navigate these complexities, being in that state of mind where you are also dealing with loss, and perhaps at times there are kids involved in it.
Yeah.
So let's look into the law of succession and just tell us more about what really happens when someone dies
Right.
and they leave a property behind.
Right. So I'll try and minimize the information as much as possible because the law of succession is so wide. So I'll only talk about the two main facets, the two main areas, and then talk about the aspect of the property. So when someone dies, they either die what is called testate or intestate, which means testate meaning they died with a written will in place, and intestate meaning they died without a written will in place. Most people die without the written will in place, but that does not mean that they don't have property. So the very first myth I want to debunk is that going for succession means you have like millions in terms of property. As long as you have property, then for you to be able to transfer this property to the next person, you have to go through the courts, which is now what is called the probate process, which is now under succession. Probate meaning going to court for the court to determine where this property is going to go. So the decision as to where the property goes typically lies with the person who owned it, so the person who's now passed on. So with the benefits of having the will in place is that you'll be able to decide who gets what property. However, that can be, people can challenge that in court. Yes, based on what it is they feel they've received. Is it an equitable distribution? Because really it can't be equal all the time.
Yeah.
Is there a child or a spouse that's been left out? Noting that with wills, you cannot purport to disinherit your children, neither can you divorce your spouse in a written will. So that's now when it comes to testate succession. And that's I've sandwiched this, into like two minutes. Then when it comes to intestate succession, which is now most people, there's no will in place. There are properties, bank accounts, and property we're meaning bank accounts, artwork. People now buy, even cameras because they are very costly. Shares in companies, various things. That's what now property entails, right? So when it comes to now title deeds and things like that, that is property that will be subject of now the succession process. So when we're coming into that process, we need the list of assets and we need the list of liabilities. And property can also fall in assets and liabilities to this extent. If this is a property that's being charged, then the bank or whichever financier you use is a creditor. So there is a liability in the sense of a loan that's being charged on the title as against the title to that property.
Yes.
So it's not fully owned by the person who's passed on. So then that becomes a slight challenge in the time of succession because the bank or the financier is involved in that process as co-owner. Remember, when it's charged, the bank has
Yes.
an interest,
On the
and that
property.
interest is written as against the title. So if there's a loan as well, whether it's charged or not, that is a creditor to the estate of that person who's passed on. So when it comes to that process, you have to involve everybody, and that's where the challenge comes in. You must involve everyone who's a dependent and a beneficiary. Dependent by way of they were beings provided for by the person during their lifetime. So it's a spouse.
Yeah.
And that's why it's very dangerous for people to take care of other people continuously for an extended period of time when they're alive. Because if this person comes for your succession, during your succession proceedings in court, they can claim to be a dependent.
Whether they're blood related
Whether
or
they're
not.
blood related or not. So the people who've informally adopted children because they were, like in the village or somewhere in Nairobi, less fortunate people, relatives,
Yeah.
and you keep sustaining them for extended periods of time. There's also the danger of adverse possession. And I think we had a little chat about this,
Yeah.
where if someone stays on your parcel of land without force or secrecy for 12 years plus one, even when the person dies, they can come in and say, listen, I've been on this property and this person knew about it. In as much as it's in their name, I even developed on this property and they never chased me. So adverse possession can accrue, which then means the family is at a risk of losing the interest in that property because someone was staying on that parcel of land or in that apartment, which, apartments now have their own titles because of the Sectional Properties Act. So because of that, people are at risk of losing property if they have long-term dependents, if they have someone who has stayed on their property for 12 years plus one. And we say plus one because of that, and it's even plus 1 day. It doesn't even have to be plus 1 year, just as long as 12 full years have lapsed, and it's continuous years.
What if there's an agreement, like more like a lease, where you've agreed you're going to stay here, and perhaps there could be lack of monetary exchange in terms of the compensation?
Right.
Because you've seen that in rural areas where you probably give someone because you don't want idle land, people will come and settle, but you want to give it. What happens in such a situation?
Is it 12 years plus one? Because the adverse possession requirement is 12 years plus one without force or secrecy. So if they meet that criteria, even if a lease was in place and no money was being exchanged, then it's an overriding interest in that sense. They have actually stayed on your parcel of land without force or secrecy for 12 years plus one, which is also why when you own a parcel of land or you own an apartment, you need to keep checking up on it to make sure there's no one encroaching on it. And if you're giving permission for someone to be on it, you need to actually have an activity on that parcel of land so that you still purport to own it in that sense.
Yeah.
Because otherwise they'll come to court and say, hey, listen, this person died, but I have an overriding interest. I have a greater interest than other people because I've actually been on this parcel of land. I've actually been in this apartment for 12 years plus one, so I want to own it. Now, the court can decide one of two things. Either they give you the right of ownership, which means they strike out the former name and issue a new title in the name of the person who's been there 12 plus one, or they allow you to purchase it if they don't see like you fully met the criteria or that the interest of the family of the person who's passed on is greater. So let's say, it actually varies from case to case when it comes to adverse possession. It's not entirely blanket, like if it's 12 plus 1 period, you still have to prove your interest is greater than the owner or the owner's family. So there's those aspects with regard to the property of, a deceased person vis-a-vis the family members, friends, dependents, and beneficiaries. So beneficiaries would be the people who benefit from the estate of this person who's passed on. So generally, the properties of this person are called estate of the deceased person.
Okay.
Yeah.
Let's look at the surprises that get a lot of women who are married.
Right.
Where family comes in case of a spouse death, and they start contesting on matrimonial property you acquired with your husband, your late husband. My question would be from just a scenario that I've encountered in the market where you, as a woman, you invest together, you start paying up loans, but then you're married in a bigger family. And the assumption always is that it's our son, it's our son's property.
Yes.
And they get all into this rival, some are pushed out. What really is the legal recourse for such a case?
So it depends. Did the son, this is still a succession process, right? Has ownership, the first question I'd ask is, has ownership passed, and whose name is the title?
Let's give it two scenarios here, where one, they have invested together, all right, and it's in the name of the husband, sorry. And with that said,
and it's during the term of the marriage.
Yes.
So he died when the marriage was intact, and this property was gotten during the marriage.
Yes.
Then it is presumed. Remember what we said in episode 1. It's presumed to be matrimonial property.
Okay.
So it was in his name, held in trust for the spouse or for his family, his immediate nuclear family, being his wife and children.
Yes.
So that's scenario 1.
Scenario 2, the lady, they were gifted a property. That property had a charge. You just talked about a charge where a bank has an interest, a financial institution has an interest in it. But in this case, the man was not able at the point of the gifting to run with the monthly payments of the bank. And unfortunately, the dad-in-law passes on, the husband passes on, and the family comes for this property. And she's just, as usual, you're an outsider to the in-laws most of the time.
Yes. So in that scenario...
because it's a lot of people are going through it.
Yeah.
What advice would you give them?
So in this scenario, you have to look at it from a point of, you want to prove that her interest, always we're fighting for the interest in the parcel of land, or the interest in the title is greater than the interest of somebody else. So what is her interest? Her interest is the consideration paid, consideration being the amount of money she advanced into that charge, right? Toward the repayment of any monies. So that is the interest she has. So if she has made payments toward it, then the aspect of gift lapses. It becomes an aspect of ownership. So there's an angle like that. So it's just about how you're able to look at it legally to be able to fight for the rights of this person. And then also it's a gift in contemplation of what exactly. So remember, there's something I mentioned in episode 1 again about gifts in contemplation, of death, and the time limitation for that, and that they can be rescinded. So if strictly speaking, it's looked at as a gift, then there will be a problem in terms of proving whether or not this was rescinded. Because if this person died without a will, then the other family can claim, listen, he said certain things before he died in way of an oral will, right? And an oral will, if there are witnesses who are competent and they were there and they can prove, because they will be questioned, if they are proved in court to be saying the truth about this oral will, then the gift will be nullified. To the extent of the consideration given. So what will happen is she might not get the parcel of land, but the court will instruct in terms of listing who gets what at the very end in the confirmation of grant, that she gets an amount commensurate to or equal to that which she paid for that parcel of land. So she becomes a creditor as opposed to a family member in that succession proceeding. Because if it's found truly that, listen, the gift could have been rescinded because the family is saying something different, it's fine. So if you don't need the parcel, if you can't get the parcel of land, you paid X amount, so from the net estate, you will get that amount as a creditor.
Okay.
So it's almost as if you're getting a refund, or the contract was nullified. So you're getting, so you're pretty much getting that refund.
So let's talk about investments that are done secretly by a spouse who lives, and the outsider, the Susie, in most cases, they will come knocking at your door,
Right.
right? How does the law look into that
So,
when it comes to the succession process?
okay. So Susie, for those who missed
Yes.
episode 1, Susie, and I hope there's no Susie watching and catching a
listening.
feeling. It's not personal. It's from a statement Susie come lately.
But it's quite common
But it's
at the
quite
moment,
common that
yeah.
there are Susies who are coming in and claiming ownership of certain properties. And the properties they tend to claim are prime properties. So the issue here would be, are they sharing ownership? Is it joint ownership? If her name is on the title, then this is not even subject to succession, sadly. Because she's an
Wow.
owner. So what are you
Okay.
fighting for? Are you fighting for his share in the property? If so, then maybe. So it depends on the kind of ownership this is.
So you can fight for his share.
You can fight for his share in the type of ownership because there's joint ownership and there's in common. So in one of them, you can fight for it. In the other, it goes automatically to the other person who owns it. So it just depends. You have to look at the title, and your lawyer has to advise you on what is on the title and what you can fight for and what you cannot fight for absolutely. Because if you put in the one that involves her being able to, because someone has passed on, all she needs to do, she doesn't need to go through the succession process. She'll get a hold of the death certificate, go to the land's office with a copy of that certificate and the title, and she'll gain 100% ownership. So you just need to check. Your lawyer would have to advise you based on joint tenancy or joint ownership or tenancy in common.
At that point, I think I need to advise men when they're investing. They need to think about the bigger picture, because you can ideally just end up leaving your family in agony. And really a traumatizing situation.
Because also, Lucy, if the person, let's say that she's not on the title, but she's coming to say she's lived on this apartment, or there's something that she contributed to, whatever contribution she's claiming, right? And this is property that maybe was purchased in the existence of his marriage. Just because she's living in that house and she contributed to certain aspects in that house, this is the clincher of the Succession Act. She's not a wife for purposes of succession. She gets nothing.
Oh, wow.
She gets nothing. And the thing about it is, if she has children, the children are entitled to part of the estate just like any other child, because children are innocent, right? But she gets nothing. If she's not part owner, she gets absolutely nothing. But then again, it also forms part of matrimonial property in this sense, because remember, it was purchased during the existence of the marriage. So that becomes part of, property that cannot be challenged by this woman. And then even as she's coming into these proceedings, what is she calling herself? A beneficiary? Is she calling herself a wife? Is she calling herself a dependent? Which she has to prove. So ideally, that apartment, that house she's living in that's not in her name can be challenged.
Does this rival really end when it's where do you put a stop, especially when there are chaos in such a situation?
You see, the
How
rivalry,
long does it take for succession to complete?
Right, so probably I just give you estimated timelines for succession where it's not contested. Because once it's contested, then that's a whole ball game because of the kind of applications people file. So if it's not contested, you file it with all the documents being correct. So if the documents are correct, then it goes to gazettement for 30 days. After 30 days, you file a copy of the gazette as proof, and you proceed to the next step, which then the court will grant you to gazette it a second time for 6 months. After that 6 months, you come back for confirmation of grant. So estimated 8 months to a year for an uncontested succession case. And this is if courts are giving quick dates. So there are too many variables as well. Courts giving good dates, close dates. And then also your lawyer being able to file documents quickly and correctly. So if the court needs to keep prompting you on the judiciary portal, you need to bring in this document, then it delays the matter further. If the court is not, like I have several matters now, that they were approved, like one of them was approved for gazettement on the 12th of June. Until now, it's not been taken to Kenya Gazette. Wow. God knows why. So that has delayed it for 3 months, and the next court date we're given is in November. So that's another 3 months, a 6-month total just for gazettement of 30 days. So the client is the one who, the estate of the deceased person, the proposed administrators, because they're not even administrators yet, so their petitioners really are the ones suffering.
Yeah.
And all this time a dispute is going on for ownership of certain properties.
Yeah.
So that's what extends it. Then now, if someone comes in as an objector, objecting to the issuance of the grant to this person,
Yes.
by way of them saying, I am a beneficiary, I'm a dependent, and I've been left out. Now, Susie and company. Now, if they come in, or a cousin somewhere who says they've been a dependent, or your shosho who says she's, rent is paid for her, all those objectors, they have to be heard. Each application heard on its own. Or they are heard together by way of people filing what is called a reply to the original petition and a cross petition. So all those processes have to be heard. So that can delay a matter. We've heard of certain cases, we don't want to mention their names because they're ongoing in court. They've been going on in court from 2003, some from 1980, and they're still going on. These are estates worth billions, and as this is going on, lawyers' fees is racking up to the billions.
They end up actually paying lawyers every benefit they get out of it.
So it doesn't. It's just because they cannot agree on what is called the mode of distribution, and it's because each house, and most of these are polygamous setups, right?
Yeah.
Each house cannot decide on who gets what amount or who gets what property. Most families fight over property than money, because of the value of the land at that time and how it appreciates and the value of the asset thereon on that parcel of land. So like now where we are, if the value of this land is 400 million and the asset itself is worth 4 billion, guess what? We will not fight over the 1 million in the account.
No.
This is what every family member, this is what the villagers will come to fight for by claiming dependency.
Yeah.
This is what the last born in the family who doesn't want to work will come to claim for. And this is why people go for trusts, because with a trust, you can actually determine who gets what, and it cannot be challenged in court. Yeah.
You've mentioned so many things and there's so many questions in my
Ask
head.
the questions.
So when I look at the boy-girl child and property rights, property ownership, I think the law has changed where a parent can divide assets equally. It doesn't matter if it's a girl or a boy, because we had this traditional element where girls would be married, they will own properties on the other side. Which brings me now to my question. Daughter-in-law, sons-in-law, and property rights.
Yeah.
Right? When I look at situations where daughters-in-law, because even sons-in-law, you could be married somewhere, but then you're an outsider. Something of this happens. So you, as a daughter-in-law, as a son-in-law, how does the law of succession look into that with the property rights that you are indirectly or directly, if I may put it that way, you could be entitled to some property by your significant other?
So this is where the importance of at least some kind of written document, a sale agreement, a will, comes into play. Let's use a variable like this. Dad passes on. He has grown children who've all married, and he had spoken by way of an oral will. Each son is going to get parcel A, B, C, and D, and each of the sons are married. And then once he passes on, son A dies. So the daughter of that house is now fighting to get parcel A, and the transfer had not been done because dad and son died maybe 3 months apart. So before they could even start dad's succession, son A has passed on. But it is common knowledge among everybody that the sons A, B, C, and D are supposed to get parcel A, B, C, and D.
Yeah.
Then now a dispute arises where the widow of dad, mom-in-law, says, no, she cannot get. I want us to redivide this. I have a parcel, right? Then A is further divided between B, C, and D, leaving the daughter-in-law out. So when they're doing dad's succession, they have to pass it down according to dad's wishes. So dad's wishes were A, B, C, and D. But you cannot pass it to a deceased person.
Yeah.
So do you now get the parties to agree by way of mediation to go in the route of dad? Because what would have happened is, had it been transferred, the interest would have passed to the son, and then the wife would have had an exclusive priority, what is called priority, to claim this, in terms of as when she's petitioning
Yeah.
in his estate, whether he has a will or not. Now, if the son had a will, and in the will he mentioned this parcel of land that dad was gifting him, the question then would be, was this all the gifts that dad was giving, were they in contemplation of death? Because if it's a gift in contemplation of death and he dies within that timeline, then that gift, if it is written down, or if any of the sons says this is a gift in contemplation of death and all sons were to get equal parcels,
Yeah.
then that is done away with by the court, in the sense that the court now sees for sure son A was supposed to get parcel A, B, C, and D, because you cannot disinherit your children.
Sure.
So you get someone to tie themselves in court by mentioning the aspect of dad gifted all of us equal parcels of land. So he just died, but that does not negate the gift to his household. So then it forms part of the son's succession, where the wife can claim, listen, part of his assets included this that was not fully transferred. And it also applies to people who are purchasing land from someone who passes on in before the transfer is complete, or just after signing a sale agreement, or just when money has passed but this agreement is yet to be signed. The intention was that sale to take place. That's what the court will look at, and this person then gets an interest in that land because of the consideration, i.e. the purchase price that they have paid.
What if he hasn't paid the deposit? What happens?
If he hasn't paid the deposit, it's almost as if nothing has happened, because now we can't work with nothing.
Just assume a sale agreement was signed today.
Right.
The funds were to be transferred tomorrow.
Yes.
And that death unfortunately happened.
Death of which person? The seller or
The
buyer?
seller.
The buyer has not passed consideration. You can't deal with a dead person.
Okay.
Yes.
So
if consideration has passed, then there's part performance of that agreement. If consideration has not passed, but people have signed, then what exactly are we working with? Will the family agree for the consideration to be? Because the completion, there's parts of the contract that if they are done, then the court can say, fine, there was an intention. The reason we say sign the agreement and pay the money at the same time is to cover for those instances. Because there are those who now pay earlier and then sign later, which still covers for that instance. But if you follow the money later, the question then becomes, did you only pay because you had someone died and you're trying to cover for yourself? Why was the delay there? Why did you delay in performing your part? Was the financier involved? Is there an agreement with the financier? Because there are several other elements that have to be proven to show an interest. Now, because money has not passed, then there's no loss to any party. And that's a question that courts ask.
It's quite interesting because as a realtor, I've gone through that.
Right.
And I could probably share my story so you can share expectations of buyers who find themselves in that situation.
Yeah.
I remember, I think 2 years ago, I was just doing a normal transaction. 30 days into the transaction, the seller passes on. We had already put in the 10%. And the family on the other side spent part of that money. Because initially, and this is why at times I always say, listen to your realtors. My buyer sent the money directly to the owner's account. Right? And at this time, after the unfortunate occurrence happened, they actually had access to our account and they spent part of that money for burial expenses. And now, fortunately, there was a bank that had an interest in it. So my client panicked, and now it became my responsibility to get the entire of the deposit back to him. All right? And it was just like, which now my question comes to, in such a scenario where even families are not agreeing on the succession, because we ended up knowing, we were dealing with the owner, and the motivation behind the sale was that the family doesn't agree on anything, even small matters.
Yeah.
And she needed money for medication. So after we had done everything we had done, my client panicked in the sense that he might end up losing his money.
Yes.
Because the expectation on how the process would have taken, there's a bank involved. He's now the one that is losing on this scenario.
Yeah.
Now, if we magnify on the legal issue around this situation, what advice would you give to a buyer who might find themselves in that situation?
Get your deposit and get out. You don't want to be part of a succession proceeding
Yeah.
and you did not complete the 90% because it might be an uphill task. They'll change.
Yeah.
And then they might change later. With succession proceedings, it's the same advice I'd give to someone who wants to purchase land that's subject to succession proceedings. Don't do it. Wait until they're finished, then come back and say, listen, now if you guys are still willing, we can proceed. But wait until they're done fighting internally. Because if you form part of that fight, you might end up losing your deposit and losing a lot in legal fees.
Yeah.
So if you already have your 10% and they've spent it, then you're a creditor in that estate. Move the court by way of an objection through your lawyer for you to get back your 10%, go and invest somewhere else, or get back your 10% and then see if the family is still willing to sell. Most are not. Unless they still need the money for other things, in which case they are willing to sell. But is that ancestral property? Is it community property? Because if it is, you're buying air. Yeah, hot air at that. So you really just need to pull out and find another lucrative investment for either the same amount of money or less or slightly more.
You know, I found myself in a legal complexity. As a realtor, what would you advise? What are the legal steps we should take in such a situation?
So this is when your client has already paid the 10%. First of all, clients need to start listening to us. We're the professionals because we tend to see what's going to happen. We see the pitfalls. We can see a risk from afar. Of course, it is our job to also warn you of risks.
Yeah, sure.
But of course, we're working with a situation where there are clients who do not listen to legal advice. So when you're proceeding, Kenyan investors.
Yeah.
So you, first of all, you indemnify yourself. Have it in writing that this person has refused advice. So that later on they do not come and say, and have them sign it. I do it all the time. If you do not listen to legal advice,
Realtors,
I indemnify
I
myself because later on someone will take a complaint against you to the body, the respective professional body. And if you do not have a piece of paper signed by this person or an email, address this person saying, this is my advice. This is as per the meeting we held on the stage. You said you'd rather proceed a different way, but you still want to retain counsel, or you still want to retain us as a respective agent or realtor. So this is the action we're going to take, but please take notice that you rejected professional advice. So that's the first thing, indemnify yourself. You took years building your business, you have to protect your brand. And then second, you look for ways to still cover your client even after they've made that purchase, right? Or paid that deposit. So you take all necessary steps. Is it an agreement? Following that agreement to make sure that timelines are followed by the financier, by the other parties. So if let's say the seller dies, you have to reach out to the seller's family quickly and notify them, listen, on this date, this agreement was signed, copy attached. On this date, payment was made, copy attached, proof of payment attached. So our client is still desirous of completing this transaction, and upon you guys filing for succession, one would like to know that you want to proceed with this transaction because it's very important for us to know. And two, if you do, then what are the terms once you have completed, or alternatively, we can be enjoined in the succession proceedings. Then now we make payment, right? But you list us as the owners in the confirmation of grant. Our client becomes the owner. So it transfers, the transmission is done from the dead person to our client directly, as opposed to going through the estate and then, because that's a further cost. And by doing so, you avoid some of the taxes. When it goes through succession and you direct it to the person purchasing or to family, it does not attract certain taxes.
Oh, wow.
Yes. But if you do it the three-pronged way, like it goes through succession to the family members, then that second step to the purchaser, it attracts the normal taxation. So you'd rather mediate with the families to make sure that the buyer is taken care of in terms of just being the direct as it would have been if the person had lived on. If that is not workable, which can happen, then your client is enjoined by force, by way of an objection or a protest, into the succession proceedings in court, and then now what you're claiming is just that deposit or the amount that was paid.
Yeah.
If they're not agreeable to selling, you can't force someone to sell. A contract has to have a willing buyer, willing seller.
Yeah.
So yeah,
Wow.
yeah.
You know, as you're talking, I'm just thinking of now we know somehow death is inevitable.
Right.
Right? And we have to plan for the unplannable. So, what advice would you tell us in terms of planning for the unexpected to just avoid family rivals,
Right.
you know, have clear direction? This is how I want my estate to. What advice would you tell someone today to do?
Okay.
Yeah.
So my camera, have a will, have a trust. Very important. Succession planning. It's not morbid to have a will. It's not morbid to have a plan in place. And like you said, it's to avoid, in as much as you can, that infighting. I mean, in having a will, I'd also say, especially gentlemen, to be honest about how many children are out there. Don't let the kids come and start fighting for a space or a piece of the cake. Because they are entitled to that property by law. They are entitled to their estate or part of their estate by law. So have a will in place. List down all your assets. Don't make your family start hunting, title deeds all over the place.
Yeah.
It's quite unfair because majority of people, men and women, when they purchase land, like, we mentioned in the previous episode about sole ownership and then joint ownership. When it's sole ownership, we tend to hide those titles and those share certificates so well, nobody knows where they are. At least when you're having your will done, your lawyer should have copies of those titles, and even they'll have the original will in store. So when you pass on, there's someone who actually knows you have 15 properties in this country, maybe 2 abroad and whatnot. That safeguards the aspect of, it protects your family in the sense that they will have something that you've left behind for them. But then now also in your will, make sure your will is not revoked because there's technicalities to drafting your will. Do not disinherit your children in your will. The will be thrown out. So basically you entered into this succession, your executors entered into the succession process with a tested succession, meaning you had a will. But then there's a ruling made that the will is null and void because you disinherited children, which is illegal. Or you said, my wife has been useless, or my husband has been useless, has not helped me at all.
There are people who do that.
Yes, there are people who divorce, in quotes,
Okay.
their spouses in their wills. So that revokes the will in entirety, right? Then there are those who don't provide for former spouses, we call them exes, but the law calls them former spouse. You've gone through a proper divorce process. You guys divided matrimonial property. So there's no need for me in a will to provide for a former spouse, right? But the former spouse now comes during succession to say, listen, I'm a former spouse, right? They're not entitled to anything. If everything was dealt with at the point of matrimonial property, what are they coming for? Because now there's nothing for you. There's no relationship anymore.
So are you
If
trying...
at all, if matrimonial property was divided at the
Yes.
point of the divorce, you
Yes.
cannot come later to claim part of an estate that you walked out with something at the point of the separation.
Okay.
Yes. So I was about to say Clandays, and then I was just like, let me be sensitive. For Susie's, we need to find another name.
No, I love Susie.
No, I think we just change it to Mary Jane, so
No,
everyone feels equally
Susie
protected.
Good.
So for the extra persons, right?
Yes.
If they're coming to claim for property, they have to have some kind of joint ownership in place. So they're
Yeah.
protecting the interest they have with regard to maybe some consideration that was paid, they purchased or co-purchased with the
Yeah.
deceased person, or whatever it is, just because their name is on the title is interest enough.
Yeah.
But they just cannot come for property. And that goes to the people who are called intermeddlers, which is a criminal offense. You know those relatives who wait until people have died, then they come collecting title deeds, collecting
that.
property, collecting keys to houses
Yeah.
and cars. That is intermeddling, and it is a criminal offense. So basically, there's
There's
the
a
aspect
penalty
of-
to that?
Yes, there is.
Okay.
There's a penalty to that. And there's a fine and a term of imprisonment if found guilty.
Wow.
So people have to just wait for the succession process to run its course, yeah? And if you're not entitled to property, you're just not entitled to it. Work hard for your own. there's the aspect of priority in terms of who gets what and who can file for succession.
Yeah.
It's always the spouse first, whether it's a wife or a husband, and then the children of the deceased person. So if there's no wife and no children, it's the parents of this person. If there are no parents because you've died, after your parents, it's your siblings. If you are an only child, then it's your grandparents and cousins. If you never knew these people, then it's the state. So everything you owned ends up going to the government
you're
of
talking
Kenya.
about meddling
Yes.
with estate for the deceased, and I'm looking at scenarios which I've like being part of, or rather experienced, where a father dies, a mother is left with the kids, and they're big. Just say this is like first generation.
Right.
Then customary land, and there is no clear. The father left like a verbal will. This needs to be done.
Right.
And it gets to a point where the kids can't see eye to eye. But then they go ahead, some of them who are probably on the side of the mother, right, to sell off, and money is exchanged, but there's no documentation. Is that part of meddling, that you could actually take someone to court?
You can actually take someone to court for intermeddling, but you have to look at the parameters of this intermeddling. So if everyone was colluding to sell off this parcel of land, but they're part of the family of the deceased person.
Assume it's like two siblings who are excluded.
Right.
The other siblings are in solidarity with the mother to sell off, and they don't really care. And now it comes to the monetary contribution, whether you're taking care of the mother or not. Favorism, that kind of situation.
Well, when it comes to filing, remember there's something I mentioned just a bit earlier about being a beneficiary can go to court and say, listen, I didn't get enough from the estate of my dad, or from the estate of my mom. So if it's seen that from this parcel of land, say it's the only asset the old man left, and mom gets something because they're selling off, they're already intermeddling, they're selling off. Brother and sister, older brother and sister get something, and then the last children, the last two probably get nothing. Then the court will compel the others to ensure that there is property that can be divided and distributed to the other two. Because the question will be what has been left of that parcel of land. You see, if they've already started hiving off and selling, there's nothing much you can do because now third parties are involved. If consideration has already passed, even if there's no documentation, if money has passed and someone else claims to own and a hived off parcel from the main parcel, if there's something left, then they can get that by way of that order of the court.
Yes.
If there's nothing left, then whatever part of the estate is left will be given to them. So again, if we use the example that this is the only parcel of land that Mzee left, then whatever monies, they'll be forced to give account of the estate. And whatever monies are remaining will be given to the two who got nothing. Yes. So they can be forced to give account.
Oh, wow.
Yes.
Good. Now let's talk about family members. They're not married, but they're very heavy in investing, and they leave, and this is left to the siblings. How is that handled? Where maybe, assuming my brother leaves massive investor, and he left, and he has not, he's died,
Right.
and technically he doesn't have a will. How his estate going to be handled?
Right. So if it doesn't have a will, it's remember priority.
Yes.
Parents,
First.
then siblings. Yes.
What if there's a child?
Right. So it's the child, parents, then sibling. So if
The
the child
child
is
comes
under
first,
18, the person filing for the court case, the probate and administration case, will be a trustee, acting on behalf of the child as an administrator of the estate. So basically, the child will be getting, all the properties of their late father, but someone will hold them in trust for him until they turn 18, when the transfer is supposed to take place from the name of the administrator, or because it will be listed as Lucy holding in trust for the child. So now when the child turns 18, then the proper thing will be done where you now, because you can't deal with it just like that when it's holding interest, right? So at 18, you now transfer it into the name of the 18-year-old. Yes. Because it will be deemed that the properties they were amassing were for this child.
Yeah.
Yeah.
We are talking about planning for the unplanned. A will or a trust? Which one would you
Have
advise?
both. And I say it this way, the trust is such a cold way of doing things. In this sense, for trust, it can't be really challenged unless you're challenging how the trustees are dealing with the assets of the trust. Because they'll no longer be assets of the deceased. They're transferred into the name of the trust.
Yeah.
So if the trustees are not paying out monies that are supposed to be paid out, or if at the age of 35 people are supposed to get certain parcels of land and this is not being done, that's the only time that the beneficiaries can run to court and say, hey, listen, we're not getting the term, what is that part of the terms of the trust.
Yeah.
So the trustees are put, held to account.
Yeah.
But you can't challenge how I've decided things should be given out in that trust. So it's a very safe way, and it's for the long term.
Yeah.
It protects the estate for a very long time, right? It has succession plans. So if the first generation passes on, it's up to the next generation. So if they're supposed to get 35,000 per month, and the firstborn dies, the children of the firstborn get 35,000 per month, like that. So it's a long-term succession plan. With a will, it's a good thing. So when you have both the trust and the will, what you do is put the bulk of your assets into the trust and have the will to just say, asanteni sana kwa kuwa familia yangu, and this is what's going to happen. I refer you to the trust. Because with the will, what happens is people tend to spend everything all at once.
Yeah.
So I'll
that's
list
true.
out everything that is my property, and then I say, I will give Lucy this, I will give Mary this, I will give Susie this. And then the problem is everyone is going to spend everything all at once. But when you give them a bit every other day, then it lasts for a long time. Remember, it's the estate of the deceased, not the estate of the family members.
Yeah.
So you still have a right to give them. They need to work for their own so that they pass it down the way they want.
That's so true.
Now, it's for you to give them bits and pieces of what belongs to you, even after death.
And I think that kind of like motivates people to work.
Yes.
You also motivate your kids to work for their own.
Yes.
Not just to rely on what you're doing. Now, with that said, there's something that's very common. Someone could actually leave a massive property to a driver that was very loyal to them.
Yeah.
Let's talk about that a little bit.
So if that's in a will, of course, people will contest that
Yes.
because there has to be equitable distribution of estate. So if you give your children a net, like for all your kids, say you had 8 kids. I'm a fan of people with 12, 15 children, so fill the earth. It gives us more to work for in terms of succession. So if you have 15 children and you give them a total of 15 million, but then your long-term driver, you give him a car worth 40 million, let me tell you what's going to happen. The kids will run to court saying this is not equitable distribution of the estate, right? We're not disputing that the driver has been there. We're not disputing that you should get something.
Yes.
But he can't get more than what all the children have gotten in total. Because the priority is them.
Yeah.
So what might end up happening is the sale of that 40 million vehicle, and then it's the proceeds of that sale are redistributed, and the driver gets something, but it will not be 40 million. It might even be 1 or 2 million. Yes.
Wow.
But now with a trust, you can actually do that. You say to my long-term driver, the car you've been driving, I gift it to you exclusively for your use.
Wow.
So if you decide not to share it with any other person, possibly you want to do that so that your kids' secrets are kept. You know where he used to take you? You want him quiet. So you give him that car.
Yeah.
Yeah.
Parting shot.
My parting shot is for people to be wise. When it comes to estate planning, succession planning, you have to be wise about your assets. Remember, even the Bible tells us to leave it to our third and fourth generation. We're working for our kids.
Yeah.
So the best way to do that is to ensure that we are saving up properly, investing properly, get the right agents to help you in picking out the right kind of properties that are in good areas, that are appreciating in value, things that are marketable, And then also trust nobody,
Yeah,
but have
sure.
your documentation in check. Have your will, have your trust. Get a good lawyer to assist you to get all these things on board. Put your documents in a very safe place, very safe place, you know. And then just be wise. Being wise helps. It really does.
Wow.
Yeah.
Thank you so much for sharing that.
Thank you.
You're out there, you're going through, or rather, you're just looking at your family dynamics and you have a pressing question. Feel free to reach out to us. You can leave a comment, and I'll definitely bring back Madam Mimi to just answer your questions. I know this is a very, very sensitive matter, and I think we all are going through it in one way or another. Feel free to reach out, and we'd be more than happy, or I would be more than happy to have another conversation to just answer your questions. Thank you for listening, and I'll see you in my next episode.